Hello everybody, welcome to this match. So hello in Nigeria, hello in France, hello in the Netherlands, and whoever actually is watching this match on YouTube. We are here today for the second match of the 8th of finals, because we had one earlier today. So today is a match between two of the 16 teams who got qualified after the group phase. One is University of Lagos, representing Nigeria, and one is the Catholic University of Lille, so Université Catholique de Lille in French, who is as well here. So we have complete teams on both sides for having this match today. And I would like to start with first the introduction of each participant for this match. So I will start with Miss Njoku Augusta Shinwe Bam.
Good afternoon, everybody. My name is Augusta Chinwubam Njoko, and I'm a 400 level law student of the University of Lagos, Nigeria.
Thank you very much. Welcome, Miss Pelacia.
Good afternoon, everybody. I am a student from the University Catholique of Lille. I am in my Master 1 International and European Law. I hope I have finished successfully this first master year. And I will specialize in international human rights law next year. And I am really looking forward for this debate.
Thank you very much. Miss Alonga Gloria Oziu.
Good afternoon, everyone. My name is Alonge Gloria Ozio. I'm currently a fourth-year law student at the University of Lagos, Nigeria, and I'm really excited to be here, and I look forward to a fruitful debate.
Thank you very much. Then I'll give the floor to Miss Ambre Polycarpe.
Hi, everyone. I'm Ambre Polycarpe, and I'm a student from the Catholic University of Lille. I'm in the first year of international and European law, and I look forward to this debate. Thank you.
Thank you very much. And then Mr. Adedayo Michael Adeshina.
Hello everyone, good afternoon. My name is Adedayo Michael. I'm a second year law student at the University of Lagos, and I look forward to an interesting debate with you.
Thank you very much. So together with my colleague we will host this match. So I will just give now the topic that you already got 10 days ago that you had to prepare. So the topic is: it's constitutional for the public authorities to infringe fundamental citizens' rights in times of public health crisis. So this is a topic that you got, and now in a few seconds we'll know which position you will have for this match. Knowing that, yes, you might be either in favor, either against. So up, we'll share my screen, and then you will see the algorithm. So normally you should see in Nigeria and in France that there are two possibilities for each team to be in favor or to be against. So we just click, and then we'll see which position you will get. So in favor, this is University of Lagos for this match, and as a consequence it will be the Catholic University of Lille who will be against. So it means concretely that the University of Lagos will start with the opening statement defending the position that it is constitutional for the public authorities to infringe fundamental citizens' rights in times of public health crisis, and on the other side, Lille will defend the position that it is not constitutional for the public authorities to infringe fundamental citizens' rights in times of public health crisis. So now my colleague will set the timer for 5 minutes for you to review your argumentation, and in 5 minutes we'll start with the University of Lagos argumentation. You can close your camera and audio if you wish. Time is up, so we start. So you can open your cameras. So for this match, as the University of Lagos got the position in favor, this is then the opening statement that we will hear. So I would like to give the floor to the University of Lagos for the opening statement. You have 4 minutes.
Thank you very much. Just before I start, am I visible and audible?
Yes, you are.
Thank you. If it were up to me, I probably would never stop for a red light or even wear a seatbelt. Now, while everyone has the right to personal liberty, the line is drawn when this personal choice endangers the lives of millions of others. And as we have seen during the COVID pandemic, reckless individual acts hinged on reckless assertions of civil rights during a public health crisis gets people killed. My name is Alonge Glorious, and in 4 minutes, I would be arguing that infringement on citizens' rights during a public health crisis is constitutional. My argument is based on 3 salient points. First, that the state's duty to protect and preserve lives overrides individual civil rights. Second, that restricting individual rights during a public health crisis is in line with the precautionary principle. And lastly, that it is legally recognized by the limitations of public health and necessity. First, the state's duty to protect and preserve lives overrides individual rights. Article 12 of the International Covenant on Economic and Social Rights recognizes the right of everyone to the highest attainable standard of health and charges states to take steps towards the prevention, treatment, and control of diseases as may be necessary. In the Canadian case of Toronto against Deakin, a patient suffering from tuberculosis was detained for treatment. Now, he argued that this was a violation of his constitutionally recognized liberty. The court, however, specified that even if there had been an infringement, it would have been justified by the state's responsibility to protect and preserve lives. Secondly, restricting individual rights during a public health crisis is in line with the precautionary principle. According to UNESCO, when human activities may lead to morally unacceptable harm that is scientifically plausible but uncertain, actions shall be taken to avoid or diminish that harm. It is therefore legal for public authorities to prioritize taking actions that prevent the spread of infectious diseases, including restricting certain individual rights like the right to movement, personal liberty, and others for this purpose. Lastly, infringements on civil rights are excused by the legally recognized defenses of public health and necessity. The Siracusa principles recognize public health emergencies as a ground for the restriction of individual rights. Article 25 of the ILC Draft Articles on State Responsibility also recognizes the defense of necessity. In other words, a state is justified in restricting the rights of its citizens during situations of necessity, including a public health crisis. Now, it is pertinent to note that even in times of public health crisis, derogations from human rights are never arbitrary. Rather, states are required to follow due process. As was explained in the American case of Jacobson against Massachusetts, states are mandated to only act out of necessity, take the least restrictive action that will affect public health, and ensure that the restrictions to human rights are proportionate to the public health risk. In conclusion, this motion highlights the story of people like Anthony Karam, a 27-year-old man from Western Sydney, Australia, who refused to self-quarantine after testing positive to the COVID virus. His entire family ended up being infected by this deadly virus, which eventually claimed the life of his father. What our counterpart colleagues propose is the encouragement of recklessness, negligence, and murder masked in the name of civil rights. Thank you.
Thank you very much. So now it is time for the Catholic University of Lille as well for the opening statement of 4 minutes. So you have the floor for 4 minutes.
Before starting, could you please confirm that I am audible and visible?
Yes, you are.
Thank you. Dear jury, dear colleagues of the University of Lagos, thank you for being here today. I am Leticia Pelacha, and I will be pleading on behalf of the counter-argument. As such, I will sustain that it is unconstitutional for the public authorities to infringe fundamental citizens' rights in times of public health crisis. Considering the submission made by my learned colleague, the statement lodged by the pro party shall be declared inadmissible. We will debate again through three main arguments. Our first argument is the use of derogable clauses are a threat for the rule of law. The second argument relies on the fact that derogable clauses during emergency stages are a threat with regard to the violation of fundamental citizens' rights. And with our third argument, we sustain that the condition under which those derogation clauses can be applied are not enough precise. I will come back now on our first argument. Our first argument, which states that derogation clauses, in order to be applicable and used, should meet a few criteria. They shall indeed respect the proportionality principle, the necessity principle, the non-discrimination principles, and shall be limited in time. But all deprivation of liberties for states' emergency sake are not respecting those criteria. But the emergency states are still allowed. This is a real threat to the rule of law. Indeed, as I said, the few criteria, such as the proportionality principle, the necessity principle, which is the one which is necessary for protecting the nation and responding to a threat, the non-discrimination on the basis of race, color, sex, language, religion, or social origin remain compatible with the state's or other international law obligation and last only as long as necessary. So those deprivation of liberties shall be limited in time. This is according to Article 4, paragraph 1 of the International Covenant on Civil and Political Rights. It is also according to Article 27, paragraph 1 of the American Convention on Human Rights, and on Article 15, paragraph 1 of the European Convention on Human Rights. Beside that, there is also this derogation from that the national government has the power to interpret to which extent this derogation can go. A state normally shall also suspend those rights by first being obliged to inform the relevant international body at least twice. And so the initial notice shall include the reason for suspending rights under the respective article and the specific rights they have derogated. For example, the American Convention on Human Rights also requires the government to provide a set date for the termination of each suspension. All this to tell you that mainly those steps are not followed by the states, which renders the use of such clauses completely illegal. And only the fact that we invented international human rights law in order to protect human rights and be agreeing by legally putting aside this through those derogation clauses triggers and challenges the rule of law. The second argument will focuses exactly on this violation that I just mentioned previously, and the third argument is that we are not expressing enough the conditions under which those derogation clauses can be applied. Thank you for your attention.
Thank you very much. So now we move to the first round of rebuttals. So I will give the floor to the University of Lagos for the first rebuttal. You have 2 minutes.
I would like to confirm if I'm audible and visible.
Yes, you are.
Okay, thank you very much. I'm going to start my speech now. Honorable judges, the said that derogation is a threat to fundamental rights, but we refuse the premise because, honorable judges, what our counterpart colleague did not consider is that people can be reckless and negligent. Their actions in themselves can be threats to state security and public health. This was testified to by Patrick Sawyer, who urinated on public health workers after being told he had Ebola. His action would therefore lead to the deaths of 2 nurses and the widespread of the virus in Nigeria. Were it not for effective restrictions on affected people's rights, more than 8 people would have died. At times like this, derogation of certain rights is a state's duty. Again, the rights infringed by states and public authorities in these cases are not those that are absolute rights, but qualified rights like the right to privacy, right to expression, movement, and others that you mentioned that worsen the crisis when left unchecked. We say that it is the constitutional duty of public authorities to protect the right to life and dignity, the 2 most important rights, always. They also said derogation clauses are illegal, but we deny this premise because derogation clauses is recognized in various jurisprudence. The suggestion that derogation or suspension do not occur when because when you consider binding international instruments which are incorporated into the Bill of Rights of many countries, grounds of suspension of fundamental rights are usually public emergencies that threaten the life of a nation, and this stems from the philosophy of derogation. This premise is supported by Article 4 of the ICCPRO and Article 15 of the ECHR. These instruments that so jealously protect the fundamental rights of people concede that individual rights must be sacrificed at times when the life of the nation is in danger. This is consistent with various national and international court decisions. We refuse the arguments of the opposing side on this grounds. Thank you.
Thank you very much. So now we give the floor as well to the Catholic University of Lille for the first round of rebuttal. You have 2 minutes.
Thank you for your arguments, dear opponents, but I must respectfully disagree. Fundamental rights cannot be ignored or violated depending on the circumstances. Such freedoms are too important to be passed over, even when the state is facing danger. Such fundamental rights, such as the right to life, provided by the Article 3 of the Universal Declaration of Human Rights, or even the right to be recognized as a person, Article 6 of the same text. Those rights are inherent to the man, should be considered and applied no matter the circumstances and external factors. These freedoms are too important to be violated, and a public health crisis shouldn't be a danger to those rights. Furthermore, it is in those times of health distress that fundamental rights should be protected the most, and not, on the contrary, be infringed. In a democratic state, freedoms such as equality between people, interdiction of degrading or inhuman treatment should be strengthened at all costs in order to protect the public order and to face a sanitary crisis. The role of the Constitution is to set unalterable rules, a common ground for each and everyone to obey. In democratic states, fundamental rights are part of the Constitution, because the role of the Constitution, and therefore of the state, is to protect and provide for those rights, according to the philosopher Locke. It is in the light of those facts that I have to stress that it is not constitutional of public authorities to infringe fundamental rights, because they go against the essence of the Constitution and of the state itself, which is to protect its population's freedom. Thank you.
Thank you very much. So now we move to the second round of rebuttals. I would like to give the floor to the University of Lagos. You have 2 minutes.
I would like to confirm if I'm audible and visible.
Yes, you are.
Thank you very much. Honorable judges, they said that human rights cannot be violated on any grounds and that public health crisis is not a justification for derogation. But this is obviously against various international instruments and even constitutions of nations. As a matter of fact, although the Italian constitution is silent on matters of derogation, the Constitutional Court's case law says it is constitutional. Also, as a matter of fact, although France has no provision for derogation in its constitution, it is one of the 8 countries that had relied on its right to derogation under Article 15 of the European Convention during a state of emergency. All these are evidence about derogation or limitation exists in various jurisprudence. As a matter of fact, examining international human instruments, which are incorporated into these constitutions, they allow derogation on grounds that are justifiable, on grounds that they are proportionate, on grounds that are necessary, and achieve the objective aim of the derogation. This is consistent with the provision of Article 4 of the ICPR and Article 15 of the ECHR. In addition to the points we have already made, we would like to point out the fact that doctrine of margin of appreciation is an international principle that supports the derogation of fundamental rights. Mike, Mike.
Are you done with your part, or?
Hello?
Yes. Did you finish your part, or?
Hello?
Yes, we had a cut. Yes. Do you hear me now?
Hello?
Do you hear me?
Yeah, I can hear you. I can hear you now.
Yes. And did you finish with your part just earlier?
No, I was unable to finish my book. I got locked out. We have lots of internet interferences in Nigeria. I'm very sorry. Would you allow me to continue my point?
Shall we restart?
Yes.
Yeah.
Your time has been paused, so you can restart from the sentence.
Okay, I can restart my sentence. Okay. Honorable judges, note that the doctrine of margin of appreciation is an international principle that supports derogation of fundamental rights and has been established in several cases, including Andesite versus UK and Lawless versus Ireland, where the European Court implied that when fundamental rights are threatening to public health and public safety, it is consistent with international law and public interest. The states derogate from these rights, and this is also consistent with the provision of Article 15 of the ECHR. Nevertheless, we would like to state that under international law, states derogation are only justified when they meet certain conditions, and that arbitrariness is not justified. We support derogation, not arbitrariness. Thank you very much.
Thank you very much. So now it is time as well for the Catholic University of Lille for the second round of rebuttal. You have the floor for 2 minutes.
Thank you, dear opponents, but I must disagree. As much as the public health and public order must be protected and respected, it is a possibility that states can use the state of emergency and exceptional power to abuse their competences and violate fundamental rights that haven't any link with the circumstances. And that, even if organisms are made to control and to limit those abuses, they still exist. Firstly, I have to introduce the example of the Nigeria case. The government has implemented a new bill to allow the state to act against the COVID-19, the Control of Infectious Disease Bill 2020. However, this bill is controversial because of the constitutionalism of the text. In fact, it grants authority to an unelected executive and provides them the right to consider any territory as an isolation area. Furthermore, it allows public authorities to act without warrants and use as much force as necessary to enforce the act. And finally, the bill also threatens the right to privacy and data protection, in that it permits mass surveillance and contact tracing. Those information seems to be contradictory with the principle of the rule of law. Other infringements of fundamental rights have been observed in the context of the pandemic, which cannot be excused by the public health and order. It is the case of freedom of speech and expression. According to a survey of the Law Library of Congress, legal acts regulating mass media and restrictive measures establishing different control over the media outlets have increased in over 20 countries in the world during the COVID-19 pandemic. We can state Armenia, Nepal, Pakistan, Russia, or even Kenya, just to name a few. In conclusion, we can't accept public authorities to infringe such important rights, no matter the circumstances. Doing such is unconstitutional because it violates the principle of a democratic state and of the rule of law. Thank you.
Thank you very much. So now we move to the conclusions. So we start with the conclusion first by the University of Lagos. You have 2 minutes.
Thank you very much. Before I start, am I visible and audible?
Yes.
Thank you. When the world is facing an unprecedented global health crisis, one that requires a global response with far-reaching consequences for our economic, social, and political lives, the priority of every good state is to save the lives of its citizens. Ladies and gentlemen, good afternoon. My name is Augusta Chiwobam Njoku, and in the next 2 minutes, I'll be presenting our closing statement in support of the topic that it is constitutional for public authorities to infringe fundamental citizens' rights in times of public health crisis. By Article 4 of the ICCPR, and as confirmed by the United Nations Human Rights Committee, in an exceptional emergency situation where there is the urgency to preserve life, states have authority to adopt extraordinary measures. For instance, during the COVID-19 pandemic, over 100 countries introduced extensive lockdowns to slow down the transmission of the virus, and it worked. In January 2020 alone, the lockdown of Wuhan in China that led to a temporary restriction on citizens' rights to freedom of movement successfully reduced the spread of the virus by 60%. Also, the number of new cases declined by 50% within 4 days of the lockdown. Today, the number of deaths from COVID-19 stands at over 6 million people, and it has been said that if not for the lockdowns and restrictive measures, many more may have perished. Just like China, Nigeria introduced such extensive lockdown measures, and we must clarify that those measures worked perfectly to curb the spread of COVID-19. In conclusion, considering that a derogation from human rights obligations during a public health emergency is backed by law and oftentimes a necessity, and since states have the primary duty to protect the lives of their citizens, we submit that any derogation by a public authority under these circumstances is in fact constitutional. Thank you.
Thank you very much. So now I give the floor as well to the Catholic University of Lille for their conclusion. You have 2 minutes.
Before starting, could you please confirm that I'm audible and visible, please?
Yes, you are.
Thank you. Thank you, dear colleagues from the University of Lagos, for your arguments, but we must respectfully disagree. We do agree that it is constitutional through the use of derogation clauses limited in the time, but not through all the additional limitations set for public health emergencies in the International Covenant on Civil and Political Rights, in the American Convention on Human Rights, and in the African Charter on Human and People's Rights. When talking about the right to manifest or practice of one's religion, when talking about the respect for private and family life, freedom of movement, freedom of assembly, freedom of association, and freedom of expression. There is no need to declare a state of emergency to limit individuals' rights under international human rights law, because there exist exactly those additional limitations for public health emergencies. And we consider that not only non-derogable rights shall be respected amongst human rights during emergency states, all human rights shall be respected at all times, always. As a consequence, we're asking you, dear judges, to consider the pro-arguments used by your dear colleagues from the University of Lagos in the light of our counter-arguments. We thank you for your consideration.
Thank you very much. So from now the debate is finished, is over. So now you are not anymore under I would say review by the judge. I mean evaluation by the judge. So we will be able to simply ask your impression about this match, and after we'll give you some more information about the following steps after this match. So I would like to start with Miss Chinweumbam Augusta Njoku.
I'm really happy to have participated in this particular round. I really liked the topic, first of all, but then the research was kind of tricky because human rights is a very sensitive topic, basically. But so far, I enjoyed every bit of it, and I'm happy to be here.
Thank you. Miss Pellaccia?
I'm really happy to be here, and the arguments used by the colleagues from the University of Lagos was incredible. I mean, we were again disappointed because we had to, let's say, follow arguments that were not, we didn't agree with. And so we were really hoping to have pro arguments, but yes, it didn't happen. This is part of the game. So thank you for rendering this game challenging, and I had a good time. Thank you.
Thank you very much. Miss Alonga Gloria Oziu.
Okay, I'd like to say thank you to our counterpart colleagues for an amazing debate. And I think, as has been rightly pointed out, human rights is a very tricky and sensitive topic. And seeing that we all witnessed the COVID pandemic, and we also things that happened in various countries all around the world and are even still ongoing due to the COVID pandemic and managing that with the rights of citizens, I think this was a very spot-on topic that was tasking but interesting. So thank you very much, everyone.
Thank you very much. Then Miss Polycarp.
For me, it was a really interesting topic because I didn't have any class on it because I'm in the first year, so I didn't have much knowledge. So it was really interesting to search up on Google and to read articles and to learn a lot more about this subject, which I really like. And it's still interesting to see the different methods and way of debating that each team and each country has, because it's always very different and it's always quite interesting to me. And so it was really cool to discuss with you and to exchange our ideas as usual. Thank you.
Thank you very much. Mr. Adedayo Michael Adeshina.
Okay, so when we actually got the topic, I was quite excited, but at the same time, I was not exactly excited because human rights is a quite broad issue and it can be very controversial, like counterparts can take into. Well, so it's good. I enjoyed your entire process and I enjoyed debating with you from Lille University. So thank you very much for an interesting debate.
Thank you. Thank you very much. So yes, it was a very interesting debate indeed. You did a lot of good work concerning the preparation, so we couldn't feel it. So what will happen is that, of course, we'll receive the results from the three judges during the next days, and you will receive by email the forms from each judge concerning your performance, and then we'll know which team qualifies to the quarterfinals, which will be around the end of May. So as well, don't forget, as my colleagues we will tell you, that we have some activities as well for you coming up, and yes, we'll be very, very happy to see you, all of you as well, participating, and simply for networking, for making new contacts, and yeah, Miss Urbanova.
Thank you, and thank you all of you. It was an honor to witness your debate, and well done on your research and use of the research in your debate. Indeed, oftentimes when you are professional practicing law, you end up defending arguments that you might not internally agree with, and that's one of the skills that this competition is focused about. You research both sides of the argument and are then required, based on the luck, would assign your position and defend it in front of public. And to this end, another thing that the competition does is to connect all the students and universities. You have already experienced this to a certain point in the group matches. And now in the upcoming event, networking event on 12th of May, starting with 6 p.m. of Hague time, we'll be opening the virtual doors on the Gather platform to all the students that registered. So if you haven't yet booked your spot, do so, because if we are over a certain number of registrants, we need to book the spots on the server, and then only the people that have reserved their spot will be able to access it. So to that end, we really look forward to seeing you there. We have certain group activities that will make it easier to connect with the teams that you have had matches before, as well as the teams that you haven't met yet. And you can have both group discussions as well as individual discussions. And we also hope to see the judges that will be grading this match there as well. since you will too be able to meet fellow colleagues that have graded matches in the group phase as well as here in the elimination phase, as well as faculty members and coaches of the teams. So perhaps a good discussion to start on collaboration or exchanges between the universities as well.
Yes, I think in the chat there are questions because I saw popping them up now. Yes.
I believe the question is regarding the finals of the competition. At this moment, the competition is fully virtual, since that was the I would say the expectation that we had when we were starting the promotion and planning of the competition due to the COVID-19 crisis. Should the situation change, of course, we'll let you know by the end of the May. But for now, we don't anticipate the finals to be taking place in person. Of course, it's possible to travel, and our team would do as much as possible to arrange the live streaming of the match, even if the two teams meet up in person. So the actual judging and the observation of the match will still be virtual, or at least hybrid.
Yes, so we'll see how it goes, of course, during the next weeks. But indeed, for the moment, it's fully virtual. So I have a last question for both teams, traditional question that I ask to both teams when they meet for the first time. So I would like to ask the Nigerian team if any of you have been in France already or in Europe. So, yes, no? Not yet?
No, we've never been to we've never been.
But you would like one day?
Yeah, hopefully one day. I feel it will be really interesting to experience the culture and the ambience out there. So hopefully one day.
Okay.
And I also imagine that they have good network connections there too. Yeah.
Yes, certainly. So one thing to know about Lille is that they have a campus in Lille, but as well one in Paris, right? Is it true, in Lille? Yes.
Yes, but I have to say I am close to Paris and I've never been there, so maybe one day I will visit the campus of Paris too. Maybe with you guys.
Yeah, of course. And on the side of Lille, have you been in Africa or in Nigeria or in general? Miss Pelacha or Miss Polycarp? Have you been in Africa?
Personally, I've only been to Tunisia, but only in one city, so it's not that much, but I would really like to go to Nigeria. And I saw some photos of your campus, just did some research and looked really nice, actually.
And Miss Pelacha?
It is on my to-do list, hopefully, once I've achieved my my master too, and I will finally have the money to do so, hopefully soon enough.
Okay, so you can start, of course, making connections, because it's on a long term. So the networking is not just for few months. It's you never know where you might end up in terms of jobs, in terms of positions and organizations. So it's really important to start early to do networking. So it's and as well, if you need an expert, this is how actually it works as well. So yes, so we hope to see you again this weekend, this Friday, sorry, for the networking session, and
Thursday.
Of course, Thursday, sorry.
Thursday, 12th of May, 6 p.m. Dutch time.
Voilà, 6 p.m. Dutch time, but for you it's the same time zone, I think. So yes, and of course we'll have some activities you will see that we cannot tell you now, but you will see that it helps actually to make even more connections. So thanks again, and we'll let you know as soon as possible the results, of course, and then we'll see you this Thursday, sorry, online for OnGather. So thanks again, and wish you a good rest of the week, starting, of course. Thanks again. Bye bye.
Okay, everyone.
Thank you. Bye-bye.
Thanks. Bye.
Thank you. Bye bye.
Bye, everyone.
Thank you.